Hi everyone, Michael Truman here, partner attorney with Munitions Law Group, and today we have a major update on the new federal firearm restoration process. So just to lay the groundwork for anyone who hasn't watched any of our prior videos, there's been for decades a process written into federal law. The specific citation for anybody who wants to look it up is 18 U.S.C. 925C, and this law said that anyone who was prohibited from under federal law from possessing firearms could apply to the Attorney General to have that restriction removed. The problem is that since 1992, Congress had completely defunded this process. The Attorney General had actually delegated authority to review the applications to ATF, and Congress then prohibited ATF from reviewing the applications. So the process was completely shut down ever since 1992. And then in March 2025, the Department of Justice announced that they were going to be reopening the process, and they basically said that they were going to revoke the authority for ATF to review these applications, which therefore reverted it right back to the Attorney General's office to get around the funding ban. And they said essentially, stay tuned, we're going to be publishing more information on this process soon. So we waited for months and months to get more information, and now we finally got it. They published a proposed regulation that talks about what the restoration process is actually going to be, who can apply, who can't, or what the qualifications are going to be, how the applications are going to be looked at. We finally have that information. And just to dispel one kind of rumor I've seen online is this process will work for federal convictions. It'll absolutely work for that. If you're successful, it will remove the federal firearm ban. But it will also work to remove the federal firearm ban for state convictions. A perfect example of that, as I mentioned in one of my prior videos, was Mel Gibson already had his gun rights restored. He got to cut the line, but his firearm ban stemmed from a state domestic violence conviction. So this process absolutely will work to restore firearm rights at the federal level that were lost due to federal convictions, as well as state convictions and other state issues like mental health commitments, things like that. So to kind of dive into what does the proposed regulation say, the first one is who can apply. I think that's really the thing that people are probably most curious about. So anyone can actually apply. There is no one in the proposed regulation, there's no crime, there's nothing that says that certain people can or cannot apply at all. So anyone can apply. But what they have done is they have created certain categories of people who are presumptively disqualified, absent, quote, extraordinary circumstances. So the people who are permanently presumptively disqualified, the big ones are violent felons and sex offense felons. Those are obviously the two really most serious categories of crimes. So I'm not surprised that they're saying that those people are permanently presumptively disqualified. Again, violent felons, sex offense felons. But to recap, those people can still apply. They are just presumptively disqualified absent the extraordinary circumstances. The next criteria they set up is a 10-year presumptive disqualification for drug distribution felonies and misdemeanor crimes of domestic violence. So for the drug distribution felonies, what they said in the proposed regulation is that even though these felonies are not directly violent, the criminal enterprise of drug distribution leads to violence, it's related to violence, so we're not going to treat it quite as harshly as something that is, truly directly violent, but we're still going to put a 10-year presumptive disqualification. And same things with misdemeanor crimes of domestic violence. Even though it's a misdemeanor, it still involves violence, so we're going to put on this 10-year presumptive disqualification. And then finally, they established a 5-year presumptive disqualification for everything else. So any other crime that took away your gun rights at the federal level, they're saying it's a 5-year presumptive disqualification. In calculating the time periods, you were going to look to the date the sentence was completed, not the date of the conviction. Of course, sometimes for certain lower level offenses, those can be the same date, but if the date you completed your sentence was later, that's when the clock starts running to calculate the presumptive disqualifications. So that's the criteria as far as who can apply and how the applications are going to be judged. Next part is application components. Now, we don't have the actual application yet. I assume that at some point they are going to print an actual application that will guide people through this process. That is not out yet, but they did list a pretty thorough list of what needs to be included. And an application must include a statement of what federal disability applies. So did the person lose their gun rights because of 922G9, which is domestic violence? Is it 922G4, which was a civil commitment to a mental institution? Is it 922G1, which is a crime punishable by imprisonment for a term of 1 year? You have to say what applies. Next, you're going to have to sign and provide a release of records, which is essentially going to allow the Attorney General's office to dive into any aspects of your life and criminal history. They're also going to want relevant paperwork documenting the conviction, adjudication, commitment, whichever of those applies. They're going to want the relevant paperwork that documents it. So, for example, for a conviction, they want a copy of the charging instrument. So for most people, that's your complaint or your indictment or information. They want a copy of any guilty plea or plea agreement, if that exists. They want a copy of your judgment entry of conviction, and they want a copy of a document showing that your sentence was fully completed. They're going to want official law enforcement fingerprint cards. They're going to want a background check, a state background check from every state that you have lived in since the age of 18 or for the last 25 years, whichever one of those periods is shorter. They're going to want an affidavit from both the applicant as well as at least 3 non-family references. And those affidavits, they're pretty specific on exactly what they have to say. And that's essentially it for what the actual application has to include. Now, there are other things that you're going to be able to submit along with your application, but that's the list of what it's going to have to include. Next, the proposed regulation talks about how the applications are going to be evaluated. And as a general matter, they are taking a very holistic approach, a very broad review of who the applicant is and their criminal history or other relevant, mental health, as the case may be, that history. So what they said that they are going to look at are all prior convictions for any offense, the seriousness of the conduct involved in any prior convictions. They're going to look at charges that were pled down in exchange for a guilty plea. They are going to look at your conduct while you completed your sentence. So did you comply with probation terms? Did you pay your restitution? Did you pay any fines on time? Things like that. They're going to look at your past and present use of controlled substances. They're going to look at your complete arrest record, even for arrests that did not result in charges or convictions. They're going to look at and see if the person has ever had any restraining orders. They're going to see if there's any evidence that you've made threats or violent threats specifically. They're going to look at any evidence of mental health issues. And this one's interesting. They're going to look at comments from the chief law enforcement officer in the locality where you reside. So as part of the application process, you are actually going to be required to serve a copy of your application on the chief law enforcement officer where you live. For most people, that's going to be either your county sheriff or your local chief of police. And then there's going to be a portal set up where the chief law enforcement officer can comment on your application, either positively or negatively. So whatever the chief law enforcement officer says, they're going to take that into account. And then finally, they're going to look at whether not granting the application could potentially result in the person's Second Amendment rights being violated under the United States Constitution. For clients that have hired us, we're going to be putting all of this together, all these materials together. Of course, we're also going to be putting together a pretty detailed memo. We've always been able to apply for restorations under state law here in Ohio where we're based. And so we've got a pretty good process and document that we have always used, and we're tweaking that, converting it to be used for the federal process. We're going to address the conviction, how the person lost their gun rights, and then we're going to do, a very detailed narrative about family, education, profession, community, charity involvement, anything that we can put in front of the Attorney General's office to help to show that this person, deserves to have their rights restored. And then, of course, if necessary, we're going to talk about, what extraordinary circumstances might apply. So as far as where, what questions are still to be determined and where we're at, one major question still outstanding is when is this process going to officially open for the general public? And for that, so what has been published so far is a proposed regulation. And that proposed regulation is currently in a comment period that is open until October 20th. So on October 20th, the comment period will close, and the Department of Justice is going to review all the comments, and then they're going to respond to the comments and publish a final regulation. The time from when the comment period closes to when a final regulation is published, there's no set time period. It's usually somewhere in the neighborhood of 60 to 90 days, but again, that can be shorter, it can be less, it really just depends on the Department of Justice. And then once the final regulation is published, it can either take effect immediately, or they can state a date in the future when it will take effect. Usually they'll say 30 to 60 days. So adding up those time periods, our best guess is that this process is going to officially open sometime in January 2026. But again, could be a little bit earlier, could be a little bit later, but that's kind of what we're thinking. Another big question is just how long are these applications going to take to review? As part of the proposed regulation, the Department of Justice actually said they're expecting 1 million applications per year, and they are devoting substantial resources towards hiring, training, and processing these applications and building a web portal that they can be submitted in. My guess is that AI is going to be at least have a part in the review of the applications, but they've given no specific guidance on how quickly they are hoping to have decisions made once applications are submitted. Hopefully it'll be just a matter of a couple months, but really don't know for sure. Another big question is just how often are these things going to be granted? Is it going to be something where the vast majority of people who apply, especially if it's a nonviolent felony, are going to have their applications granted? Or is it going to be something where only 10 to 20% of applications are granted? We really don't know how strictly they're going to be reviewing them. Another big question as a part of that is for people where that extraordinary circumstance test applies, they're in that presumption window that their application would be denied. Is the extraordinary circumstance really going to act as a de facto bar, where basically if you're presumptively disqualified, basically nothing is going to actually be treated as an extraordinary circumstance to grant the application? Or are you still going to have a reasonable shot of showing an extraordinary circumstance? We just don't know. And then the final big question that I have is this process going to survive past January 2029? January 2029 is when the next president's going to be sworn in. My guess is if a Democrat wins the next election, is that this process will be shut down relatively quickly after January 2029. Again, don't know for sure, but it'll certainly be interesting to see what the future of this program actually is. So that's the major update. Obviously, if anything else comes out, if the application is published, when we get a final regulation published, we'll certainly have another video out there to provide those updates. And if anybody has any questions, feel free to drop them in the comments, and we'll try to answer them. Thanks for watching.